dear friends, dear students, it is a great pleasure to welcome you in Rennes, in the Faculty of Law in the University of Rennes 1. I hope that everyone had a good trip, and I really hope you will enjoy your stay in Brittany. Please first let me apologize for the absence of our Dean, Professor Lambert, who initially wanted to welcome you in person at the faculty. Unfortunately, he wasn't available to this early in the afternoon, so he asked me to say a few words in his name. I also like to take this opportunity to express my gratitude to Pascal Breger. With her customary availability, efficiency, and kindness, she took care of all the logistics of the conference. Without her, the conference would not even have been possible. As you may know, this conference is the first joint conference organized within our Jean Monnet network, Legal Ambiguities Withstanding TTIP, so LAwTTIP as we call it. This is a partnership between three universities, three European universities, the University of Bologna with Professor Lucia Rossi and Professor Federico Casolari, you're here. The King's College of London with Professor Biondi, and the University of Rennes 1 with Cécile, Rapoport, and myself. This network is funded by the European Commission under the Jean Monnet Action for a 3 years period. It was launched last September and lasts until August 2019. Many activities are scheduled over the coming 3 years. Some of them specifically involve PhD and master students, and I am very pleased that some of our students will attend a summer school on fundamental rights in external trade agreement at the end of the month in Italy. Some of our activities are organized toward political stakeholders and civil society. The project also has a strong teaching dimension, virtual lectures, teaching toolkits and materials, and working papers about TTIP and other free trade agreements can be uploaded on the learning space on our network website. The purpose of our project is to provide a legal analysis of TTIP and beyond of all EU free trade agreements, as it seems that this new generation of agreements reveals a lot of issues for EU external action and offer new perspectives for the affirmation of the European Union on the international stage. With this in mind, our first conference concentrates on the institutional and procedural aspects of free trade agreement of the EU. How can EU negotiate, conclude, and implement such agreements in an uncertain environment? From a political point of view, we of course all have in mind the internal challenges we are facing, like Brexit, or the external challenges going first into, like Trump election. But it will be also from a legal point of view, and the legal point of view will be the focus of our 2 days of work. Next year, the second joint conference will be held in Bologna. It will deal with the topic of the implication of TTIP and free trade agreement for the protection of fundamental rights within the EU. The following year, our colleagues from London will organize the last conference, whose subject will be investment state dispute settlement, supremacy of EU law, and the principle of effective judicial protection. Conferences, seminar series, summer schools for PhD students, and various other things are our principal activities for the next 3 years. And it is a great pleasure for me to be able to launch our network here in Rennes in the sunshine. I hope that you will enjoy your stay in our city. And finally, I just would like to add some practical information so that everyone feels comfortable. We have here 2 working languages for these 2 days, English and French. I guess that everyone here at least understands the 2 languages, so please feel free to intervene either in French or in English, whichever is most convenient for you. Although most contributions will be presented in English, don't hesitate to ask your question in French. They can be answered in English. I wish you a very enjoyable conference.
Okay, hello everybody. So, thanks for coming. TTIP and beyond, in negotiating and implementing the EU's FTA, free trade agreements, in an uncertain environment. Quite a long title for this conference, and if I may betray a secret, this title itself remained uncertain for several months. Uncertainties have indeed punctuated our global scientific project itself. When we wrote the project, together with our partners from Bologna and London, the TTIP negotiation was still an ongoing process. The EU and its American partner even announced their intention to finalize the negotiation before the American presidential election. We now know that it was quite unrealistic. The future of TTIP negotiations is now pretty uncertain. Nevertheless, the numerous legal issues these negotiations have raised remain vivid. Indeed, apart from the external uncertainty coming from the EU's partner, the EU's American partner, several internal ones, that is to say within the EU, may also impact the negotiations and the implementation of FTAs. TTIP or not TTIP, this is no longer the question, for TTIP now stands more as the symbol, some would say a model, others would say a symptom, of a new generation of free trade agreements. Indeed, from an institutional and procedural point of view, legal issues lying within TTIP actually lie within all the FTA's negotiations in progress. And there's quite many of them. More or less 10 FTAs negotiation, either in progress or for which the adoption of negotiating directives is being discussed. And that is without counting free trade negotiations being held in the framework of association agreements. Such dynamic negotiation activity can be explained by the evolution of the EU's trade policy strategy, which was a reaction to the endless Doha round. This evolution started with the Global Europe communication and the wish to conclude FTAs with countries that have an important market potential and a high level of protection against EU exports. It took a new step with the Trade for All communication, which prioritized trade and investment negotiations with major partners, USA, of course, but also Japan, Southern Asian countries, and even China, even if it's not FTA negotiation. The new goals assigned to FTAs exceed traditional trade issues and now include deep regulatory cooperation issues, investment issues that may impact more directly citizens and local powers. FTAs then become a source of worries for the people both in the EU and in the EU's partners country. Now, if we briefly shed some light on the EU's own internal uncertainties, we can notice that, firstly, some of them are of a political and institutional nature. Brexit is probably the main one. Its consequences on the ongoing and future negotiations remain hard to guess. But it will probably weaken the EU's negotiating capacity. Brexit also raises new legal issues. The behavior of the United Kingdom during the ongoing negotiations or its willingness to start its own trade negotiations will certainly impact the EU's negotiations. Secondly, some of the internal uncertainties lie within the treaties. It's probably exaggerated to describe the post-Lisbon legal framework as a new one anymore, but the new version of the treaties have certainly not revealed all of its mysteries. And we had a recent proof of it in May with the opinion 215 of the Court of Justice. Finally, some of the EU's internal uncertainties lie within the EU's FTAs itself. Having a renewed and a wider content, they also raise new legal issues regarding their negotiation, conclusion, and implementation. In this regard, our conference aims at going over all of these uncertainties. Within this introductive report, we'll just try to enlighten the interactions that can be observed between various sources of uncertainties. Indeed, it appears to us that the uncertainties arising from the EU's external action post-Lisbon framework impact the negotiation and implementation of EU FTAs. But at the same time, the uncertainties within the negotiation and implementation of EU's FTAs raise new legal issues for the EU legal framework itself. Those will be the two steps of our presentation.
Several ambiguities derive from the legal framework of EU external action as it is provided by the Treaty of Lisbon. Those ambiguities impact the negotiation and the conclusion of new free trade agreements, especially TTIP with the USA, CETA with Canada, the EU-Singapore agreement, or those being negotiated with ASEAN countries. Those ambiguities are of a relatively classical nature regarding the conclusion of an international agreement by the EU. Firstly, it concerns competence-related issues, not only the existence of the competence, that implies the legal basis of the agreements, but also and maybe mostly the question of the nature of the competencies. Should those agreements be concluded by the EU alone, or should they be mixed agreements? As they are trade agreements, the answer to this question could be quite simple. The EU has an exclusive competence. It was the position argued by the Commission during the negotiation process of the EU-Singapore agreement, or the CETA. It is worth noting that the question addressed by the Court in its opinion 215 regarding EU-Singapore agreement only concerns the question of the nature of EU competencies to conclude the agreement, without prejudice to the question whether the content of the agreement's provision is compatible with EU law. As we all know, the Court, in its opinion, gave a subtle interpretation of the main part of the agreement. On the one hand, it confirms strongly the exclusive nature of CCP, but on the other hand, it considers that the provision regarding non-direct investment, ESDS, and the general institutional provision as far as they are related to them, fall under shared competence with member states. Secondly, the ambiguities concern procedural issues. How strong is the autonomous power of the Commission in the conduct of the negotiation process? What should be the role of the European Parliament in the concluding process? Does the agreement need a request for provisional application in any case, or should this possibility be more framed or limited? If those legal issues are not very new and are even some classical questions since the beginning of external relations of the EC, for example, since the very first opinions of the European Court of Justice in the 70s, the legal context in which they now appear is fundamentally different. And this is for two main reasons. First of all, the Treaty of Lisbon settles a new framework for the external relations of the EU. That means that these new generation of free trade agreements have to take into account this new framework and have to be compatible with it. And secondly, the amazing number of case law regarding the external relations since the entry into force of the Lisbon Treaty demonstrate the extraordinary complexity of the implementation of this framework. The Court has indeed been facing several legal questions regarding the allocation of competencies as well as procedural aspects. Most of its case law contribute to clarify the interpretation of the new provisions of the treaty, but some important ambiguities remain. Therefore, three aspects can be briefly highlighted regarding the new framework of external action and its impact on FTAs. First of all, the so-called doctrine of the EU's external action, now provided by Article 21 TEU. As we all know, Article 21 provides for a large scale of objectives and principles that are guiding the EU in the conduct of its external relations. Those objectives and principles are not especially new, and the wording of Article 21 TEU is not always clear. Nevertheless, this provision has become very important, especially since the treaty expressly provides that the EU shall respect the principle and pursue the objectives in the development and implementation of the different areas of EU's external action. It explains the new wording of Article 207, paragraph 1, TFEU, whose last sentence insists on the obligation for the CCP to be conducted, and I quote, in the context of the objectives and principles involved in Article 21 TEU. It is all the more important that these free trade agreements are very comprehensive and cover environmental matters, sustainable development, and some kind of political cooperation. They can be considered as a privileged tools for achieving these objectives of the EU external action under Article 21 TEU. This provision, Article 21, is then likely to have either substantive or institutional procedural consequences. It can be used by the court as a guideline to frame the competencies or to determine the scope of external competencies. In this respect, the way the court uses this provision in Opinion 215 in order to delimitate the scope of CCP concerning sustainable development shows the potentiality of Article 21 TEU. But Article 21 is also likely to have institutional and procedural impacts, as democracy and rule of law are principles which the EU not only seeks to advance in the wider world, but which it has to respect internally. Second aspect of EU external action framework that can have an impact on FTAs, the question of competencies of the EU to conclude such agreement. According to the ambition of the Convention for the Future of Europe, the Treaty of Lisbon intended to clarify the external competence of the EU. And Article 216 distinguishes now clearly the different situations in which the EU is entitled to conclude an external agreement. As far as the common commercial policy is concerned, the treaty is now quite clear and confirms the previous jurisprudence of the ECJ. The question is therefore not only a question of the nature of EU competence to conclude such agreement, but rather a question of its scope. Indeed, the Lisbon Treaty extended the field of the common commercial policy to new aspects of contemporary international trade, such as investment. This extension constitutes a significant development of primary EU law, as the court stated in the Daiichi Sanko judgment. But this extension raises also new questions about the exact scope of foreign direct investment provided in Article 207, and consequently the nature of the commitment included in a FTA relating investment protection as a whole. Those questions are crucial in Opinion 215. The main purpose of such agreements is to reach a comprehensive agreement, that is to say trade agreement including not only classical commitments such as the reduction of tariffs and non-tariff barriers to trade in goods and services, but also other aspects as transport, maritime transport, rail transport, road transport, public procurement, and non-direct investment. It is quite obvious that those commitments can't fall within the exclusive competence referred to in Article 3, paragraph 1 TFEU. In this respect, legal basis of the agreement has to be found in the internal legislation of the EU in accordance with the condition laid down in Article 3, paragraph 2 TFEU. The codification of the ERTA case law, as it is now interpreted by the Court of Justice since the entry into force of the Lisbon Treaty, raises new uncertainties, and it is questionable whether the solution adopted by the Court in its Opinion 215 in this respect is merely the continuation of its previous case law, or whether it is a significant evolution of the implementation of the theory of implied powers. And thirdly, the ambiguities regarding the impact of EU external action framework on FTAs, that means the institutional and procedural issues. The new free trade agreement has to be concluded in accordance with Article 218 TFEU. This provision provides for a general procedure for the negotiation and the conclusion of EU external agreement. It allocates the role of each institution, Commission, Council, Parliament, in the concluding process as a whole. However, some specificities regarding agreements falling under CCP are still provided in Article 207, paragraph 3 TFEU. The first aim to preserve the power of the European Commission in the negotiating process. It has become quite an important question as the Court, in its judgment of July 2015 regarding the negotiating directive addressed by the Council for an agreement with Australia in the field of environment. So the Court has quite slightly framed the margin of discretion of the Commission in the negotiation process in relation with special committees. Its interpretation of Article 218, paragraph 3 and 4 TFEU finds a subtle path between the two principles of loyalty and institutional balance. On the one hand, the Council shall impose to the Commission some procedural obligations, but on the other hand, this obligation shall not be substantially detailed. From a certain point of view, the Court extended, in this judgment, the Court extended to all types of agreements the procedural provisions which are already implemented in CCP. But consequently, the question can be raised whether the interpretation given by the Court in the 2015 judgment regarding Article 218, paragraph 3 and 4 is autonomous, or whether it would also apply to the negotiation process as provided in Article 207, paragraph 3. That means for CCP agreements. Specificities in Article 207 are also provide for an exception of the rule of qualified majority within the Council concerning agreements in the field of trade of services and commercial aspect of intellectual property, as well as foreign direct investments, which is quite meaningful for the conclusion of a new generation of free trade agreements. And finally, the main added value of Article 218 is the extension of the European Parliament's power for the conclusion of international agreements. As far as trade agreements are concerned, this is a direct consequence of the democratization of common commercial policy for the adoption of internal rules and the kind of the consequence on the kind of procedural parallelism introduced by the Lisbon Treaty. Therefore, the European Parliament shall now give its consent to all agreements covering fields to which the ordinary legislative procedure apply for the adoption of internal rule, which is now the case for the rule in the field of trade. This democratization of common commercial policy is, of course, very welcomed in the context of new free trade agreements, since these agreements cover fields that directly affect EU citizens' lives. And it became quickly clear that the European Parliament intended to seize its new powers to influence not only the negotiation process, but also the content of free trade agreements. Furthermore, it is worth noting that the external action of the EU has never been more democratic compared with the previous treaty. And this is quite a paradox to observe that the democratic decision process for those free trade agreements has never been more controversial. But this leads us to the second point of our presentation, in which we would like to reverse and to extend the point of view. Indeed, it is clear that the negotiation and implementation of EU's free trade agreement raise new legal issues, which consequently have a deep impact on the external action of the EU itself.
Because of their renewed content, WTO plus provisions, investor-state dispute settlements provisions, etc., and also because of the partners concerned, the so-called new generation of FTAs have generated a great mobilization of actors which are traditionally not much involved in the making of the EU trade policy. I'm thinking about citizens, I'm also thinking about the European Ombudsman, national, regional parliaments. The unexpected involvement of such actors has generated several uncertainties on the success of the negotiation processes. More broadly, it has probably affected, at least in the short term, the EU's credibility to carry out trade international negotiations, especially when it comes to mixed agreements. I would like to briefly enlighten three major demands from these new actors as far as procedural aspects are concerned, and which are, I think, a demand for transparency during the negotiating process, a demand for democracy during the negotiating, the concluding, and the implementing process, and a demand for more legal scrutiny, preferably before the entry into force of the agreements. For each of them, one should try to identify how they create uncertainty, to what extent they might imply an evolution in the making of FTAs, and how they might in the end impact the content of EU's FTAs. As for transparency, transparent negotiations have become a major issue with TTIP negotiation process. The way negotiations were conducted wasn't really different from former trade negotiations at first. But the importance of the partner, the great impact expected or feared, created an unusual demand for transparency on the results of the negotiations. This demand has progressively been taken into account quite well with the online publication of several documents of the negotiations, as well as the publication of the main results of each round of negotiations. This habit has also been generalized to all ongoing trade negotiations, even if TTIP stays the agreement for which the Commission makes the largest educational effort. More importantly, it has also created a demand for transparency on who is able to influence the EU negotiating team. This demand has been well supported by the European Ombudsman and has led the Commission to publish on a systematic basis information about the meetings held between Directors General of the Commission and organization or self-employed individuals. Improvement stays, of course, possible, but transparency is probably the best handled issue of the three demands. More transparency naturally feeds demand for more democracy. Being entitled to know, citizens, national and regional parliaments feel entitled to make, that is to say, to participate to the making of EU's FTAs. Or should I say, they feel entitled to try to stop negotiating processes sometimes. In order to do so, they use tools they already have, but for a renewed purpose. As for citizens, at the EU level, citizens use the right of citizens' initiative. We know for sure since the Tribunal's decision of May 10, 2017, that this initiative is allowed by EU law as far as trade agreements are concerned. Even if there shouldn't be a lot of, well, there might not be a lot of consequences on the CETA process itself, this should encourage new initiatives in the future with uncertain consequences on the negotiating process. I don't think such initiatives would be able, not sure they would be able to stop the processes. However, they might impulse changes on their content by suggesting evolutions of EU's negotiating position. At the national level, citizens are sometimes in capacity to express themselves through referendum, compulsory or not, on the ratification of an agreement by a member state. We had an example in the Netherlands with the EU-Ukraine Association Agreement. And in France, the National Assembly has voted a European resolution asking for ratification of the CETA through a referendum procedure. These examples show how the conclusion of FTAs has become uncertain as far as their mixed agreements. New forms of institutional cooperation could be established, perhaps through informal dialogues between the Commission and national parliaments, or better use of existing dialogues. They wouldn't necessarily imply the revision of the treaty of Article 218, especially of the TFEU, but they would enlarge the scope of internal stakeholders consulted. Why not, for example, using the public consultation mechanism but dedicated to national parliament or regional parliaments consultation. National parliaments or regional parliaments during the CETA negotiation have also been quite involved in the negotiation, which is quite unusual. It goes beyond the ratification requirement, and it has been observed even though the legal need for mixity was uncertain. National parliaments expressed a fear of being deprived of their right to legislate by both the prospect of an ISDS mechanism and a deep regulatory cooperation through joint committees. Both citizens and parliaments use procedures to obtain legal scrutiny also on the new agreements. The demand for legal scrutiny is expressed, again, both at national and EU level. At the national level, citizens and parliaments seek for a guarantee that new FTAs won't affect their constitutional rights. Cases are pending before the Bundesverfassungsgericht and before the French Conseil constitutionnel, referred to by more than 100 of French deputies. This involvement of constitutional courts might force some member states to ask for a reopening of FTA's negotiations in order to solve compatibility issues. If not, the member state might not be authorized by its parliament or by its population to ratify the agreement. At the EU level, an opinion of the ECJ could be required on the compatibility with the EU treaties. The Walloon Parliament made such a demand to the Belgian government, but has not so far been heard. No opinion nor preliminary rulings on compatibility issues have been asked so far, but the ECJ could get an occasion to evaluate some of the innovations of EU's FTAs, such as impact of the ISDS on the autonomy of EU's legal order, or maybe more generally the respect of an equality principle. Such a legal scrutiny might imply future adjustments of the content of FTAs, this time for legal reasons. I don't have time here to develop on the subject nor on the different uncertainties we spoke about, but we have a whole conference dedicated to it. So I leave it to you all